Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to LegalDoc Talk 24/7. Hey, y'all, so this is a quick update on the Cardi B and Tasha K suit. As you all know, Cardi B filed a motion to dismiss the Chapter 11 or just kind of drop the Chapter 11 down to a Chapter 7 type of bankruptcy case. And then the trustee actually found a joinder motion agreeing with the motion to dismiss the bankruptcy or dropping it down to a Chapter 7. So Tasha K has actually responded to that, and I am going to get into that. Just to let you guys know, there is a hearing on that motion tomorrow at 2:30. It is a hearing on that. So I am very interested as to how it is going to go down at the courthouse tomorrow. With that being said, let's hop right on to Tasha K's response to this motion. It reads, response in opposition to Belcalis Marlinus Almanzar's motion to dismiss Chapter 11 bankruptcy case, or in the alternative, convert uh, case to a case under Chapter 7 of the Bankruptcy Code. The debtor, Latasha Transrena Kibi, hereby submits this response in opposition to Cardi B's motion to dismiss Chapter 11 bankruptcy case, or in the alternative, convert case to a case under Chapter 7 of the Bankruptcy Code, and in support thereof states as follows. Debtor filed her Chapter 11 bankruptcy proceeding in order to promulgate a payment plan to maximize recoveries to all creditors. To do so, debtor must be allowed to maintain her career as a social media content creator. Prior to her career, debtor worked in restaurants in order to fund and build her career into what it is today. Debtor must be allowed to maintain her career in order to pay her creditors. Debtor began her career in 2015. Within a few years, Debtor grew into social media sensation with followers interested in her pop culture, wine, gossip, and comedy content. Debtor career is assisted by her husband, Cheek Kibi, and his affiliate entity, Yellen Entertainment LLC. Yellen provides, among other things, management, video production and repurposing, video editing, promotional support, and organizational and maintenance services of and related to debtor's career. Kibi has been filming since 2000 and has been an integral part of the debtor's business activities over the course of their 19-year marriage. Critically, if debtor was to engage a third party to provide all of the services, debtor's career would be cost prohibitive. And let's see what they put as footnote number one. It says Yellen's value to debtor's career is the single most disputed economic issue facing the debtor and claimant. In 2022, debtor largest creditor, Cardi B, obtained a defamation judgment against her for approximately $3,911,000, 680 oh, $3,911,680. There we go. Since then, the debtor sought to negotiate a payment plan to maintain her career and maximize payments to creditors, including Cardi B. Notwithstanding debtor's efforts, claimant refused debtor's pre bankruptcy offer. Debtor was forced to file the instant bankruptcy case in 2023. The bankruptcy case was intended to provide debtor an opportunity to preserve her career, demonstrate projections of her net disposable income, and to confirm a periodic payment plan consistent with the bankruptcy code. Now, if y'all have not watched the previous video on this, you need to go watch it because based off of the pre bankruptcy offers and the payment plan, Tasha K's attorney did some shady stuff. And I am assuming that is why Cardi B did not agree to that payment plan, because y'all was trying to do some shady stuff. That's not, she was willing to work with you. She knew, and it stated that. It stated in the motion that she knew that you was not going to be able to pay this full judgment. However, she was going to work with you to get some type of payment plan going so that you can make payments towards that. But your attorney did some shady stuff when it came to that payment plan. Y'all was submitting. I have to go back and read it, but I know that shady stuff is being done. Keep that in mind, everybody. Despite debtor and her professional months of negotiating with claimants professionals, a resolution was not achieved. So let's see. Professionals was claimant Cardi B did not directly participate in any settlement conference, despite uh, intimations in the MTD. The parties never participated in a formal mediation or judicial settlement conference. And normally with mediations, all parties, all counsels have to be there. I've never, probably because we don't do celebrities, I've never, came across a mediation where the party is not there. So I'm not sure how that worked out. Let's see. On November 22nd, 2024, debtor filed her second amended Chapter 11 plan of reorganization under Subchapter 5 for Latasha Transrena Kibi. On December 12th, 2024, claimant filed her motion to dismiss. The motion to dismiss attempts to turn smoke into fire. It creates a misimpression that debtor acted in bad faith in this bankruptcy case. I have to think about this because didn't you lie when you filed the bankruptcy petition? And I'm not laughing at anybody, but I'm laughing at the fact that your attorney said it creates a misimpression that the debtor, Tasha K, acted in bad faith in this bankruptcy case when your client failed to let everybody know she had assets elsewhere. But continue. The motion to dismiss bases arguments on pre-petition conduct and the nuisance legal significance of whether a trust exists if it holds no assets. it, it don't matter if the trust exists. It does not even matter if there was no assets in there. You still have to provide any active trust that you have. If you created it, you need to put that in there. Duh. To the extent the motion to dismiss addresses post petition conduct, it selectively discloses confidential settlement communications, omits that economic terms were agreed upon subject to finalizing non-economic terms, and misrepresents the key non-economic term that created the settlement impasse. The critical term forcing the impasse was claimant Cardi B's insistence on a non-disparagement clause. And let's see. It is important to note that Cardi B does not have a right to a non disparagement clause in the debtor's plan of reorganization. An objection based solely on the failure to include such non disparagement clause would be improper. So hold on. Bankruptcy is not my forte. So we're going to non disparagement. So, the non disparagement clause is a contractual agreement that prevents one party from making negative statements about another party. These clauses are often found in employment contracts, severance agreements, settlement agreements, partnership agreements, and independent contractor agreements. Non-disparagement clauses are intended to prevent employees from negatively affecting their employers' businesses, restrict that an employee can say about their employer after separation, or prevent the other party, excuse me, from speaking negatively about the business, its products, services, or management. Okay, so let me put in bankruptcy. Yep, it's pretty much the same thing. Dealing with a settlement agreement that prevents a debtor from making negative public statements about a creditor, even after filing for bankruptcy, essentially restricting them from damaging the creditor's reputation through disparaging remarks. So I think that kind of works both ways in these bankruptcy cases. The proposed clause was so broad that it would undermine debtor's career and invite further. Oh, okay, never. Okay, yeah, all right, got it. I'm thinking in my head and I'm answering myself. So y'all don't laugh at me. The proposed clause was so broad that it would undermine debtor's career and invite further litigation with claimant. Disparagement clause, the non-disparagement clause that claimant demanded reads as follows. Because remember, this is saying the debtor cannot speak on, the creditor in a negative light. So this is what they put in the settlement agreement. As a condition of debtors, subchapter 5 plan of reorganization, the debtor, including her representatives, her estate heirs, affiliate entities, agents, employees, contractors, other representatives, and any company in which the debtor has a director or indirect interest, collectively, the debtor parties, agree not to make, publish, or communicate, whether directly or indirectly, any derogatory or disparaging statements, remarks, or comments about Miss or Cardi B, and or her family members, her children born prior to or after the petition date, husband, ex-husband, siblings, parents, step-parents, in-laws, former in-laws, grandparents, aunts, uncles, niece, nephews, and cousins, excluding any cousins are removed than second cousins, sponsors, attorneys, managers, agents, representatives, employees, entities owned or controlled in full or in part by Cardi B and her affiliate entities in any form or medium, including but not limited to social media platforms owned or controlled by debtor parties, and or any company owned or controlled fully and partially by Chikna Kibi, including without limitation Yellen Entertainment LLC. The debtor ensure that no content related to Cardi B and or her family, whether explicitly or implicitly, will be published or disseminated on any of the debtor's social media accounts, websites, blogs, and other online communication channels, including without limitation, uh, Unwind with Tasha, the Wine Cellar Podcast, Tasha K Winos, or Tasha K Live. Failure to comply with this provision shall constitute a material breach of the plan and may result in additional legal remedies being sought by Cardi B, including without limitation the right to seek dismissal of the debtor's bankruptcy case or conversion to Chapter 7 of the Bankruptcy Code. I don't see nothing wrong with it. But I mean, you are in entertainment. If you live your life publicly, I don't think that you could get mad, at anybody commented. However, if they are saying negative things about you, that's a different story. You know what I'm saying? So, I, I can't get mad, but I understand why this clause was put in there. And so on Tasha's end, she's like, man, if I can't talk about Cardi B, I can't make no money. Lady, there's plenty of people you could talk about around here. Plenty. Cardi B or claimant is not acting in her economic interest. She seeks to sabotage debtor's career through unreasonable restrictions of her First Amendment rights. Having failed to bully debtor into accepting an overarching non-disparagement clause, claimant filed the motion to dismiss to harm debtor's career and end debtor's bankruptcy case. At all times since the filing of debtor's bankruptcy case, she has acted in good faith. Okay. Debtor promulgated a plan that accurately reflects her net disposable income, including a reasonable valuation of Yellen's contribution to her career. Claimant disagrees. Instead of both sides presenting evidence to support their positions with respect to feasibility and net disposable income, claimant now argues that the case should be dismissed on entirely unrelated grounds. Debtor must have an opportunity to present her plan to the bankruptcy court at a confirmation hearing to determine whether debtor's plan can be confirmed. Good cause does not exist to dismiss or convert this case. Motion to dismiss must be denied. This was a good, a good little, background. However, when you have the trustee side with the claimant, that's going to be a problem. The trustee actually manages all of your assets during the bankruptcy proceedings. Okay. The fact that you did not disclose certain things to the trustee, because if they're managing all of your assets, then the trustee should have known about your other 7 assets that you kept hidden. So you lied on the bankruptcy petition to even start the case. You didn't disclose that information to the trustee. I'm very curious as to how this will play in court tomorrow. So here is the official response. So the motion to dismiss post petition allegations. Much ado about nothing. What is that? The Dictionary of Cliches by Christine Amir. A commentation over a trifle, a tempest in a teapot. It is best remembered as Shakespeare's title for a comedy, but the terms were already known by the time he used it. Okay, a big fuss. Okay. Uh that went over my head. If somebody understand that, leave it in the comments below. So the motion to dismiss roundly criticized the debtor and her husband for the claimant describes as untruthful and misleading bankruptcy filings testimony. MTD at page 3. The crux of claimant's accusations is that her likely skilled professionals at a significant expense uncovered the existence of undisclosed partnerships, onshore and offshore trusts owned and controlled by debtor, her husband, and or Yellen. The motion to dismiss includes transcript excerpts of objectional gotcha questions where claimant's counsel inquire into the legal significance of the existence of trusts and entities that have no value and hold no assets. Debtor did not intentionally conceal the existence of trusts or business entities from the court or parties in interest. Now, here's a crazy thing because in the depositions, when they was putting those little excerpts in the motion to dismiss, like even Tasha K said that she like took her name off of the bank account because she knew that they will also garnish that bank account that she shared with her husband. So y'all was doing stuff that you are not supposed to be doing when you are in a bankruptcy case. The judge is about to I wish I was a fly on the wall in that proceeding. Um let's see. Okay, and the debtor amended her schedules once the legal significance of trust with no assets and companies of no value were identified. At the end of the claimant's professionals' exhaustive investigation, they did not identify a cent of undisclosed value in supposedly concealed trust or business entities. It is the principle of the matter. They ask you, do you have trust? They didn't ask, now here's the thing. And Dang, I should pull up a schedule. They ask you if you have any trust. You could have checked yes. And when they ask you what is the value of that trust, then you put zero. It is the fact that you didn't put in you clearly lied on a pleading. And it tells you like penalty of perjury. There's no way, and I'm pretty sure this is the same thing that I'm saying the judge is going to ask that. So if they didn't have any value, why did you say that you did not have any trust? But anywho's, let's go. Um All right. Claimant also alleges that debtor's actions with respect to plan negotiations could possibly form a basis to dismiss or convert debtor's bankruptcy case. Claimant states following a judicial settlement conference with Judge Hyman on June 14, 2024, and a subsequent meeting at the offices of debtor's counsel on June 24, 2024, attended by debtor, Mr. Kibi, his counsel, Cardi B's counsel flying in from out of state, the undersigned, and the subchapter 4 trustee, I'm sorry, 5 trustee. The parties came close to agreeing on the required plan payments through further negotiation was necessary. Oh, it says though further negotiation was necessary. First, the parties never attended a judicial settlement with conference with the Judge Hyman. Second, claimant did not participate in the June 24, 2024 settlement meeting or mediation of any kind. Claimant's misrepresentation that the parties participated in a judicial settlement conference is intentionally misleading to create an impression of wrongdoing by debtor when none exists. It is believed that an in person judicial statement conference of or formal mediation with full party participation could result in a resolution. Unfortunately, so far, claimant has been unwilling to participate in the same. In the end, the parties may have been able to reach a resolution of the economics of a planned proposal. Claimant's demand for a broad, non disparagement provision became an insurmountable obstacle. Having failed to reach a resolution, debtor advanced a plan with her calculations of net disposable income rather than frosted upon her by claimant during settlement negotiations. Now, they said it was something going on with that plan that they submitted. They were side eyeing that. So I don't know what type of calculations, but what Cardi B's attorney said in that motion to dismiss, those calculations weren't correct. Let's see, memorandum of law. So they're gonna put the law in with it. All right, let's see what they say. The dismissal or conversion of Chapter 11 case are governed by Section 1112B, which provides that a bankruptcy court shall convert or dismiss a case whichever is the best interest of creditors and the estate if the movement establishes cause. Although the term cause is not defined by the Bankruptcy Code, Section 1112B4 provides 16 examples of cause which justify the dismissal or conversion of the Chapter 11 bankruptcy proceeding. The motion to dismiss does not claim that dismissal or conversion is appropriate under any factor enumerated under Section 1112B4. After 27 pages admonishing debtor for alleged pre petition misconduct and her failure to disclose immaterial assets, because that's what she did, the motion to dismiss concludes without legal analysis. Instead, the motion to dismiss generalizes bankruptcy law concepts of good faith and loosely refers back to its prior allegations of either pre or post petition bad acts. To analyze whether a case has been filed in bad faith, many courts apply the following factors discussed and read of Piccadilly. Hey, is that the Piccadilly restaurant? All right. So here are the factors. The debtor has only one asset. the property in which it does not hold legal title. The debtor has few unsecured creditors whose claims are small in relation to the claims of the secured creditors. The debtor has few employees. The property is the subject of a foreclosure action as a result of arrearages on the debt. The debtor's financial problems involve essentially a dispute between the debtor and its secured creditors, which can be resolved in a pending state court action. And at the timing of the bankruptcy filing, evidences an intent to delay or frustrate the legitimate efforts of the debtor's secured creditors to enforce the rights. Well, all this legal mumbo jumbo. Let's see. So in Piccadilly, let's see. The leading case on dismissal of the Chapter 11 case in this circuit describes the existence of the following factors as indicative of a bad faith Chapter 11 filing. In Midway Investments Limited, it stated that the 11th Circuit has set forth a non-exhaustive list of factors which a court may consider in deciding whether to dismiss a debtor's case as a bad faith filing. Application of the Piccadilly factors weighed against dismissal of the case. In that court, the court must also analyze whether the bankruptcy filing masks other less savory aims. In addition to advancing a valid bankruptcy purpose, courts consider whether the debtor filed a bankruptcy case merely to obtain a tactical advantage. The purpose of filing of this bankruptcy case is completely transparent. For the debtor to maintain her career, and thus maximize payments to creditors, including Cardi B, the debtor must continue to produce high quality, entertaining social media content. Absent a repayment plan, debtor would be unable to do so to the detriment of all constituents, including Cardi B. Debtor obtained no inappropriate tactical advantage from the bankruptcy filing. In fact, debtor agreed to entry of two orders entered in an adversary proceeding, one on October 6, 2023, and the second on January 3rd, 2024, allowing claimants 3 million plus no claim and expecting it from discharge. So in conclusion, debtor one filed this case to arrange for a reasonable payment plan and to save her career. Two, did not contest dischargeability of Cardi B's claim. And three, promulgated a plan including reasonable periodic payments to creditors, including Cardi B. Debtor possesses a realistic possibility of an effective organization and filed her petition to restructure her debts and obligations in order to satisfy the creditors. Nah, lady, you had $3 million judgment on you. You was running from it, and you thought a bankruptcy case was gonna, you know, make that go. Well, I can't say go away. Delay it. Let's put it that way. You thought I was going to delay it. Nah. In contrast, Cardi B seeks an outcome to the detriment of debtor. I don't believe that. All creditors and claimant herself. Let me tell you something. If the court said and they granted, that means that they reviewed all the evidence before they made that judgment. So it's like you're saying it's not Cardi B that is seeking the outcome to your detriment. It had to be the judge because the judge is the one who ordered it. Anywho's, in contrast, claimant seeks an outcome to the detriment of debtor, all creditors, and claimant herself. Claimant is not acting in her economic interest, but seeks to silence debtor by ending her bankruptcy case and her career. The motion to dismiss should be denied, and the debtor's plan should be set for an evidentiary confirmation hearing with a briefing schedule. Wherefore the debtor, Latasha Rena Kibi, respectfully requests an order to 1. Denying the motion to dismiss filed by Cardi B, 2. Denying the conversion of the Chapter 11 bankruptcy case to a Chapter 7 bankruptcy case, and 3. Granting such other relief as the court deems just and proper. And there we have it, folks. So this is Tasha K's response to Cardi B's motion to dismiss the Chapter 11 bankruptcy or convert it into a Chapter 7 bankruptcy. So I'm gathering from this is that they feel that if they dismiss this bankruptcy case, which means that that judgment will still be in place, which means that Tasha K would have to spend majority of her years paying back Cardi B, right? That is going to be the downfall of her career. So she's asking the court, and I'm saying Tasha K is asking the court to continue with the bankruptcy, the Chapter 11, come to a agreement for repayment, in which that is what Cardi said in the beginning. They had an agreement. So even if Cardi didn't show up, there was a settlement agreement in place. However, and when I say settlement agreement, it was a payment plan. There was two, if I'm not mistaken. There was two payment plans, and for some reason you tried submitting something that I don't want to say forge. Forge is not the I have to go back and watch my own video to see what happened. But you was trying to do funny business. You was trying to do funny business with that. And so they called the whole deal off pretty much. But now you're just trying to put it in a you're trying to make it seem like if this gets dismissed and you're going to be responsible for that $3 million, that your career is going to be over. Um, I feel for her. I do, because $3 million is a lot, but it ain't nowhere near the 15 mil Blueface got to pay. But that would teach you a lesson. That would teach you a lesson. I strongly feel that if the judge felt like you didn't do anything wrong, he wouldn't have granted it in the first place, and you wouldn't even be in this position. But y'all tell me what y'all think about to happen tomorrow at that hearing on that motion to dismiss. Y'all think Cardi gonna get it? Or y'all think that it's gonna be in favor of I'm about to say Cardi B, in the favor of Tasha K? Y'all let me know in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed. Bye.